So, Chapter 4 talks about alternative dispute resolutions first. This is pretty much resolving legal disputes through methods other than litigation, so like mini trials, private trials, mediation, that kind of thing. Then goes on to talk about the advantages over litigation. So like it's less expensive, you have your freedom to choose an expert, and it preserves confidentiality between parties, preserves the relationship between parties, and talks about the negotiation and settlement. So pretty much disputant parties informally try to resolve their differences. And then it talks about mediation, which is disputant parties select an expert in a disputed area to help reconcile differences, and pretty much that the goals of this are to initiate communication between the parties and help the parties find an agreeable solution. Talks about some common uses of mediation, so collective bargaining disputes, employment disputes, environmental disputes, that kind of thing. Then it goes to talk about the advantages and disadvantages of mediation. The advantages talks about how it preserves a relationship between parties and promotes better understanding of each other's position. And the disadvantages are that it overlooks fundamental structural conflicts and gives misleading impression of quality of the parties. Talks about arbitration, which is disputing parties submit their disagreement to a mutually agreed upon neutral decision maker, or one provided for by a statute. It talks about reasons for the compromising nature of an arbitrator's decision. So, not constrained by precedents, arbitrators are interested in resolving a factual dispute, pretty much. Talks about methods of securing arbitration. So, pretty much the binding arbitration clause states that it mandates that all disputes arising under the contract are to be settled by arbitration. And then the submission agreement talks about how it's a separate agreement providing that a specific dispute be resolved through arbitration. And then it talks about the drafter's checklist, which is a checklist for ensuring that a mandatory arbitration clause is not unconscionable, I think. Anyways, and then it says that the contract is not a contract of adhesion, but it's where that's when the customer could not meaningfully negotiate the inclusion in terms of the mandatory arbitration clause. And it talks about selection of the arbitrator, which is selected on the basis of their special expertise in a particular field. It talks about the arbitrator's code of ethics. So it's basically to uphold the integrity and fairness of the arbitration process, disclose any interest or relationship that is likely to affect the arbitrator's impartiality or that might create an appearance of partiality or bias. And then talks about conduct, the proceedings fairly and diligently, and that they be faithful to the relationship of trust and confidentiality inherent in that office, that kind of thing. Talks about some of the common uses of arbitration, which are salaries, business conflicts, consumer complaints, technological disputes, and employment disputes, that kind of thing. Goes on to talk about the problems with arbitration. So arbitrators lack expertise in discrimination matters, and compulsory arbitration is or in employment and termination cases erodes workers' rights, and it has a absence of written opinions. Talks about many trials, which is when lawyers for each side present the case at a proceeding and refereed by a neutral advisor. Talks about private trials, which are cases that are tried in private by a referee who is selected by the disputants and empowered by statute to enter binding judgments. Talks about criticism, which is private trials may lead to the development of a two-tier system of justice. Goes on to talk about a summary jury trial, which is an alternative dispute resolution method that consists of things like an abbreviated trial or a settlement conference, that kind of thing. Talks about court-annexed ADR, which is courts mandate the disputants go through some formal ADR process before a case is brought to trial. Talks about the differences between court-annexed and voluntary ADR. So court-annexed is the outcome is not binding on both parties and the rules of evidence are flexible, and then the voluntary arbitration are when the outcome is binding and rules of evidence cannot be changed. Talks about court-annexed mediation, which is when the parties or the differences, the parties enter the mediation process, viewing it as a hurdle to go through before the trial. And voluntary mediation is parties enter the mediation process with the desire to work out an agreement. And it talks about the criticisms against ADR, which is pretty much the consumers are forced to give up their right to a trial when they are likely to get a higher award from a jury, or coerced to agree to arbitration because they failed to read a clause in the purchase agreement. And it talks about the global dimensions. ADR is widely favored in international contracts. It talks about the New York Convention, which is that it ensures that an arbitration award made in any of the signatory countries is enforceable in the losing party's country.